Hello everyone, welcome to Legal Darshan. In this video, we are going to discuss the case of DK Basu versus State of Bengal. It is a 1996 Supreme Court judgment and of course a famous one. Okay, so it's one of the famous judgment highlighting the menace of custodial death, custodial torture, and in this case, the Supreme Court is setting out some kind of guidelines for the police officers who are in the process of arresting a person or are interrogating a person, how they would be, treating and behaving with them. Okay, so now coming to the text of this judgment. So this judgment is a small read. I think it's a 37 pager judgment, but it is adding a lot of value to the constitutional directives, to the constitutional mandates. All right, so now in this case, what is happening? A writ petition has been filed in the Supreme Court. Before the Supreme Court, the petitioner is bringing out some cases of custodial death and custodial torture that is happening in the police custody, and is demanding that safeguards must be provided to those people, because even their even though they are the arrested person, their right to life should also be preserved, because Article 21. Okay, so when I looked at Article 21, it says no person shall be deprived of life and personal liberty except according to procedure established by law. Okay, so now when I come to custodial death, or when I come to custodial torture, custodial violence, technically in very black letter law, or very in black and white, we do not have any provisions, any legal provisions, any legal safeguards in the form of legislature preventing the custodial torture or custodial violence. Of course, we do have some liabilities created in Bharatiya Nyaya Sanhita or the erstwhile IPC, but the legislature is not very sound on custodial violence and custodial death as of now. All right, so now what is happening here? The petitioner is coming in the shade of Article 21, saying that even if they are prisoners, because an arrested person is not necessarily a person who is a convict or who is a criminal. He can also be an under trial prisoner. He can also be, kept there for interrogation. All right, so no person should be deprived of the life and liberty, is what the constitutional Article 21 read. Now, when I look at Article 22 in the Constitution of India, here also the word uses person, no person, every person, any person, because we are not using the word citizen here. We are using the word person here, which defines a wider ambit, that every person, who is in the country, who is in India, has right of life under Article 21 and has protection against arrest and detention. He has some kind of rights, which he can exercise if he is arrested or if he is under detention in certain cases. Now, here DK Basu, the petitioner DK Basu, is taking note of custodial violence and custodial torture. He is taking shade in Article 21 and 22, and he files a writ petition that, when torture, rape, and death happens in police custody, it it strikes a blow to the rule of law. It involves physical suffering, mental agony, stigma attached to it, and therefore it is a sheer infringement of Article 21 and Article 22 of the Indian Constitution. Now, the court here is, looking at this case, he's looking at the concept of fundamental rights. Court here is saying that, in civil cases, compensation may be awarded, and in private law compensation is settled. But when we talk of, public law, when we talk of constitutional mandate, or when we talk of criminal law, there should be, compensation to be awarded in public law as well, because if a person is dying in custodial torture, due to custodial torture, his fundamental right is being breached, and that falls in the part of state, because custodial death is happening. So Supreme Court is also taking a note of that situation here, that, compensation should not merely extend in private law, or in private cases between two individuals, but when there is a breach of public law due to wrongdoing, which is of a criminal nature, state should also step forward and compensate the victim. Okay, so now this case is also important because it is looking at the objective of private law, how award of compensation happens there, and what happens when the award of compensation is being made in a public law proceeding or a criminal law proceeding. Okay, so now in this case, the Supreme Court is, of course, criticizing the act of police, the custodial torture, custodial rape, or custodial death that is happening. And we are looking at the protection of an individual from torture and abuse by the police and any other law enforcing agencies. Because India is a free society and we do not foster such kind of custodial incidents. And that is why we are looking at Article 21 and Article 22 and drawing from Article 21, Article 22 Convention Against Torture, to which India is a signatory. We are looking at the word torture. Okay, so here in this case, the court is defining what torture is meaning. So torture of a human being by another human being is essentially an instrument to impose the will of the strong over the weak by suffering. So, for example, if I am an under trial prisoner and I have to give a testimony, if I have to, admit to some kind of cases and some kind of facts and I'm not doing that, then the police officer over me who is in the authority of me is strong and I am the weak, so he may impose his will by carrying on torture at me. Okay, by maybe hitting me, or maybe doing torture with me. We often see in movies, right? There are depiction of how police officers treat under trial so as to bring out the truth out of their mouth. So that kind of violence where police officer is in a strong authority and the weaker area is weaker portion is shared by the prisoners, their torture happen because police officer wants to impose his will on the weaker prisoner. Okay, so word torture is coming here in that meaning. So custodial torture, as the court is noting here, is a naked violation of human dignity and degradation, which destroys to a very large extent the individual personality. It is a calculated assault on human dignity. And whenever human dignity is wounded, civilization takes a step backward. Flag of humanity must, on each such occasion, fly half-mast. So these lines are something very wonderfully quoted in the judgment, wonderfully noted down in the judgment, where we are basically bringing out how custodial torture, it trashes somebody's dignity and degrades somebody's existence, and how it carries a long-term impact on the person, even if he or she is released sometime. Okay, so custodial rape, of course, is an offense that is listed under IPC. Section 376 did have a mention of it. Now the mention is in Section 64 that it is one of the aggravated forms of rape, where a public servant is causing rape in the custody on the women. Okay, in custody when it is happening. But when we talk of custodial death, of course, those are also punishable. Custodial torture somewhere becomes punishable, but still there is a need of having a law, having a legislature confined somewhere, right? Now, in this case, court is looking at Article 21, Article 22, and court is looking at few Latin maxims, salus populi est suprema lex, that is the safety of people is the supreme law and safety of the state is the supreme law. They are coexisting together, and so that people's safety and state safety should coexist together, the Supreme Court here is issuing some guidelines for the rights of detained person, for the rights of arrested person. I'm just coming to the guidelines. Yes, there are 11 set of preventive measures that the Supreme Court is bringing in. So when you open this judgment, first few pages, hardly 10 pages of the judgment would give you the head note. Okay, so those head notes will tell you what has been laid down in the judgment. So now here these are 11 principles. Since they are there in the judgment, I will not be reiterating it in the audio, but I will just be giving a quick summary of them. So the police personnel who is doing the arrest, he should have his name, he should have a badge or anything which is showing that he is designated to carry that arrest. Okay, so for example, in some case when arrest cannot be made by a person who is below the rank of sub inspector, he needs to show that I am designated for arrest in this case, and so that it should be openly visible that he's the police officer carrying a designation and he is entitled to do so. Now when arrest is happening, so arrestee and the arresting police officer or the arresting agency shall be signing a memo of arrest, which should also be attested by one of the witness who is one of the family members of the arrested person, or if there is no family, then any respectable member in the locality, person in the locality can do so. And if even this is not there, even if there is no respectable member found, or even there is no family of the arrested person found, then the legal aid organization or the next friend, etc., can also be taken into account. And those people who is who is attesting, or people who are related to the arrestee. Okay, so for example, if arrestee's parents are not in town, his friend is, or his neighbor is, the information shall be furnished to them that at this time and this place we are arresting the person and we are taking him to XYZ place for the custody. Okay, the arrested person shall also be given a right to hire an advocate if he wants to do so. He cannot be forbidden from the legal aid. Okay, and if there are requests for medical examination, it should be carried out within 48 hours, and it should be carried out every 48 hours during the detention in custody. And these were few guidelines that were given in this case for preserving the right of arrested person. And it was also noted that these are the guidelines, these are the preventive measures, and these should be complied along with the written law. Okay, so for written law we refer to article 21 and 22. So you cannot breach article 22 of a person. So article 22 says that if I am detained, if I am a person in arrest or detention, I have a right to know why I am arrested. Now, this also has been incorporated in Section 47 that of BNSS, Bharatiya Nagrik Suraksha Samhita. It was a part of CRPC as well, the rights of arrested person, that every police officer or any person who is arresting a person shall make it known to the arrestee that what are the grounds on which he is arrested. And similar text is found in Article 22 of the Constitution of India, that I should, if I am arrested, I should know the grounds why I am being arrested, why, what are the reasons. And when I am made known of the grounds, I do have a right to consult my lawyer, and I do have a right of legal representation, which is written here in Article 22 as well. Okay, so if I am arrested and I am detained, then within 24 hours of my arrest, I have to be produced before the nearest magistrate. Okay, this is also written in Article 22. Then when I come to Section 47 of the BNSS, it mentions that where a police officer arrests without warrant any person other than a person accused of a non-bailable offense, he shall inform the person arrested that he is entitled to be released on the bail, and he may arrange surety on his behalf. So if I am arresting a person who has done a non-bailable offense without a warrant, as a police officer, it is my duty that I should tell him that his offense is, he can be released on bail. Okay, so if the offense is bailable, pardon me, if the offense is bailable and I am arresting a person without warrant, then it falls in my duty that I should be telling the person you are entitled to bail and you can arrange surety for your bail. So this is also one of the rights of the arrested person, but in the cases of bailable offenses. Okay, so now DK Basu is basically highlighting these articles, these sections in the judgment, and saying that these mandates, statutory mandates or constitutional mandates, have to be adhered to, and along with it, these guidelines are also to be taken in account when arrest or detention is being made. One other thing that this case is noting is the judgment of Rudal Shah versus State of Bihar. Now, Rudal Shah versus State of Bihar is one judgment where compensation was awarded for infringement of fundamental rights. So the court herein is taking in account the judgment precedent set in Rudal Shah versus State of Bihar, where fundamental rights of a person was breached and he was given compensation by the state. The Supreme Court here is taking the observation that when in custody a person's fundamental right are breached, he is also entitled to compensation, even if it is a matter of public law, right? So this is one observation that I found very interesting, the interlinkage with Rudal Shah versus State of Bihar, which makes a lot of sense here. And the Court is also directing that police officers should be sensitized. Training and awareness programs should be carried out for them. Recently there have been issued some model guidelines on custodial torture and arrest, on rights of arrested persons. So legislature is taking a step forward in preserving. Judiciary is taking a step forward in preserving the rights of under trial prisoners, the right of arrested person. But however, apart from the comment on the case, we do have a need of having a law confined to, addressing the grievances in custodial torture, specifically dealing with the custodial torture and violence that may happen. So this was all for the video on DK Basu. I hope the video was useful to you. This case, along with the case of Sunil Batra versus Delhi administration, they form a great combination when you have to read about custodial torture or custodial violence. So Sunil Batra can also be read someday in after we are done with the AOR series. And I hope this discussion is useful to you. I hope uh, the videos are able to meet your demands. Thank you for staying here. Keep watching, keep liking, keep sharing the channel. Your support means a lot to us. Thank you, everyone. Have a nice day.